9 o'clock. I don't see Judge Gross' hands, but are you there somehow? Oh, here she comes. All right, we will go ahead then. We have 3 cases this morning. The 9 o'clock case is 19-1261 with Ricardo Wilson versus State of Florida. You can obviously see who your judges are. If you don't recognize us by face, you can read our names. So we will proceed. And for the appellant, if you'll let us know if you need something other than 5 minutes rebuttal time, okay?
5 minutes is fine, Your Honor.
You may proceed.
Thank you, and may it please the court. My name is Joseph Zwick, and I represent the appellant, Ricardo Wilson, in this case. Mr. Wilson is currently serving a 25-year sentence for convictions of trafficking in a controlled substance, fleeing and eluding a police officer, and possession of less than 20 grams of cannabis. I cited 3 issues in my brief. I'm going to begin with the 3rd issue for purposes of oral argument and spend most of my time focusing on that particular issue, which is that the trial court erred in denying the motion for judgment of acquittal with regards to count 1 because there was insufficient evidence for a jury to convict Mr. Wilson on count 1. The count charged in count 1 was trafficking in a controlled substance, but it's very different than, say, if you were trafficking in something that's readily apparent, such as cocaine, methamphetamine, something that's actually on the controlled substance list.
Counsel,
yes.
Counsel, can you point us to where the attorney below for Mr. Wilson made the sufficiency of the evidence argument in the judgment of acquittal?
Your Honor, the trial counsel did not preserve this issue. The only way to have this issue cognizable on direct appeal is by determining that it's fundamental error, and that is what I intend to do with my argument.
And did you raise that particularly in your brief as to fundamental error regarding the insufficiency of the evidence?
It was the insufficiency of the evidence. I don't know if I specifically cited it as insufficiency of the evidence, but I did cite it as ineffective assistance of counsel to the extent that it becomes fundamentally ineffective.
Thank you.
In this particular case, Mr. Wilson was convicted of possessing a substance which is called 3,4-methylene ethylamino valeraphenone, which is something that most people aren't readily aware of. It's a synthetic cathinone. It's a bath salt, which is essentially, in this case, the defense was that my client thought that it was Epsom salt. But on the controlled substance statute in Florida statute section 893.031, there lists basically every substance in the state of Florida that's illegal. You will not see 3,4-methylene alpha ethylamino valeraphenone on that list. The only way that that particular substance becomes illegal in the state of Florida is if it meets the qualification under section 191A by description. And that description indicates that there has to be a 2-amino, 1-phenyl, 1-propanone structure. That phrase was never mentioned in the entire record by anybody, not by the state's expert, not by the defense, wasn't in the jury instructions. In fact, the jury instructions—
Didn't the expert testify that this was a controlled substance?
That is exactly what the expert said. He said it was a controlled substance.
And how do we know, as far as ineffective assistance on the face of the record, how do we know what would have happened if trial counsel had challenged that statement or the lack of more specific testimony?
Well, it's difficult because the record, it's almost as if the trial counsel didn't even consider the possibility of raising this issue. It was essentially, the defense was that Mr. Wilson didn't know what it was, so therefore what the trial counsel failed to do—
Counsel, I guess my question really is, how do we know that it wasn't undisputed below that this indeed was a controlled substance? In other words, how do we know that trial counsel, based on our record, how do we know that trial counsel didn't investigate this and already know that it was indeed a controlled substance, and therefore he or she just decided not to challenge that?
I believe that would be fundamentally ineffective, Your Honor. And the reason for that is that a trial counsel has a duty to hold the state to the burden of proving each and every element of a crime beyond a reasonable doubt. And in this
So
particular case,
counsel's ineffective if he knows for a fact that that one of the elements will be undisputed, that he has no factual basis for disputing that element. He's ineffective for nevertheless not challenging that element.
there is no written stipulation entered in before court, so I don't believe that at this point it can be ascertained on the record that that was a stipulation. It appears much more of an omission, but at the end of the day, in this particular trial, the trial counsel did not require the state to prove that 3,4-methylene dioxy, I'm going to shorten that name, I'm going to call it 3,4-methylene dioxy for purposes of this, but the trial counsel did not hold the state to actually proving that that was a controlled substance.
Counsel,
Because
what I'm trying to ask you though is how do we know that it wasn't a foregone conclusion, right? That trial counsel knew that if he challenged it, the state would easily be able to establish that through testimony, and that there was no factual basis for trial counsel to contest that at trial. How do we know that that's not the case based on this record?
The record is unclear if anybody even knew that that was a requirement of the law. The record basically chooses to treat 3,4-methylene dioxy just as if it was something that was on the list. So Mr. Wilson—
Well, if the record's unclear, how do we find ineffective assistance of counsel on the face of the record on direct appeal?
Well, ultimately, looking at what the trial counsel did, we do know that it was not challenged. I think that assuming that there was a fact that's not in the record is something that this court doesn't typically do. There's no evidence, in the record that the trial counsel considered challenging that it was an issue, but the statute that this information was based upon does not list this substance as a controlled substance. The only way that it becomes illegal is if it meets the chemical structure that's in the catch-all provision, which indicates that it has a 2-amino, 1-phenol, 1-propanone structure. And ultimately, the jury was deprived of even the possibility of considering that this substance was not illegal, because no one ever talked about whether or not this becomes a controlled substance because of the structure that it has. So, and typically in a trial on a substance that's not on the controlled substance schedule, there is testimony that gives the jury the opportunity to decide whether or not it meets that criteria, whether it's an analyst that comes in and explains what that means to a jury, because most people don't have biochemical engineering degrees or any history in organic chemistry on a jury panel, and there is discussion about that. In this particular case, they treated the jury instructions just as if this was a substance on the controlled substance list, and the testimony was that he possessed it and it was a controlled substance, and therefore the jury found him guilty. But Mr. Wilson was deprived of the state having to actually prove that 3,4-methylene dioxy was a controlled substance. His attorney essentially stipulated to that prior to going into jury instructions, and that was fundamentally ineffective.
Counsel, you've, looking at this through the lens of fundamental error, how would you address the Supreme Court cases, particularly, I think, Johnson, State v. Smith? That was one recently where they said essentially a deficiency or insufficiency of the evidence is not necessarily a fundamental error issue. It's not per se fundamental error, and a technical deficiency doesn't always rise to that level. And how would you address that challenge in this case?
Well, the case law is clear that every case has to be looked at based on the individual facts of the case. There's not a black, clear line rule as to what is fundamentally ineffective. But this is a situation in this particular case where the validity of the trial itself was in question based upon the fact that the state did not have to actually prove that the substance that was brought in as evidence was a controlled substance. It was,
Counsel, the analyst did testify exactly that the substance that was found in the truck was a controlled substance, period. Nobody challenged that. I mean, it's going back to what Judge Eisnagel was asking you repeatedly. If everybody knew it was a controlled substance, why do you have to give the jury a chemistry lesson?
Well, as a trial counsel, your role is to defend your client, and in this particular case, that didn't happen. The trial counsel in this case went up there with a strategy that his client thought the substance was Epsom salt and did not consider even arguing that the state had failed to meet its burden to prove that that was a substance that's actually illegal. I don't know what was going through the trial counsel's head during the trial. It appears that he focused on a all or nothing defense, which involved a jury believing that he didn't possess the required knowledge of the substance, and ultimately that failed. But by not even considering the
Counsel, that sounds very much like a strategic decision made by trial counsel, which is very different than ineffective assistance on the face of the record. For us to find that, we have to assume there is no possible reason that trial counsel could have done this. And I mean, you yourself have just said, well, this seemed to be a decision made to go with this route versus this route. You can see where it's difficult for us to get to fundamental error on the face of the record if you're conceding there could have been reasons that trial counsel went this route.
I can understand that position. This isn't the other issue in this particular and what makes this more egregious is that ultimately the trial counsel allowed an expert to come in and comment on the ultimate issue of whether or not this was a controlled substance. That's something that the jury coming into this trial was supposed to be there to determine, and that the trial counsel failed to allow the jury to even make that decision. First of all, by allowing the expert to come in and testify that this particular substance is a controlled substance without going into any of the reasons as to why it qualifies, because it's not named.
Was there an objection to that testimony?
No, there was not an objection, which that's also very difficult to reconcile. I don't believe that there is any strategic reason for allowing an expert to come in and essentially say that this is illegal and this is what he had. That's not much different than allowing an officer to come in and testify that your client committed the battery, and ultimately.
Counsel, well, the defense was he didn't have knowledge of it, right? Of what it was. Why is it that if trial counsel knew that it was indeed a controlled substance, on what basis could trial counsel ethically challenge that at trial? If trial counsel knew there was no factual basis upon which to challenge, then how could counsel ethically do so at trial?
I mean, that happens all the time with defense counsel when your client has admitted to you that they've murdered someone and you're still defending them and arguing that they didn't, and arguing that the state hasn't been able to prove that your client did. So how you go about doing that is different in every case. But in this particular case, the trial counsel, whether he knew that it was a controlled substance or not, he did not require the state to prove it to a jury. And ultimately, a jury was taken with the jury instructions that this is a controlled substance. They were never informed that this is not on the controlled substance schedule. They were never informed that it's only a controlled substance if it meets a certain criteria. And the language from the criteria was never even mentioned on the record by either the expert, the judge, or counsel for either party. So it's hard to tell from the record if anybody knew that it wasn't on the controlled substance schedule. And that's ineffective fundamentally, because a jury was deprived of the ultimate fact-finding role that they have, and they were not even given the law in order to make the appropriate determination in this case.
So counsel, it's your position that it's always, as a matter of law, ineffective assistance of counsel if trial counsel does not challenge every element at trial, even if trial counsel does not have a factual basis for doing so?
It's difficult to say always. I'm always cautious to say always, because this is a situation fundamentally ineffective assistance of counsel is rare. I acknowledge that, but this is a situation based upon the totality of what was presented in court that it would have been ineffective not to at least require the state to give the jury the opportunity to decide whether this is a controlled substance. It's a very slippery slope to start convicting people of substances that are not listed on a controlled substance schedule, because that opens Pandora's box for every household item to be a controlled substance. If somebody can just come in and say, this is illegal without even telling you why, because it's not listed. That there's an understanding as a citizen of the state of Florida that you know what is illegal because of what is in the controlled substance schedule. And there are substances that are not listed that can have you spend 15-year minimum mandatories without anybody even bringing up the language for a jury to determine if that is a controlled substance. And that's what happened in this case, and that trial counsel allowed that to happen. And he did not object. He did not make a appellate attorney's job easy. However, based upon the rest of the facts in that case and what other evidence there was on that count, it would be ineffective to have done what he did in this case. And I believe it really rises to a fundamental error level and justifies.
Let me ask you there as well. Your third argument seems to sort of weave together what seem to be potentially two different arguments. One is ineffective assistance of counsel on the face of the record, and then the other one is that the trial court fundamentally erred by not granting the judgment of acquittal. Both of those arguments in your brief seem to be sort of weave together into one argument. Which argument are you making?
Excuse me, the third argument and the first one, is that what you're referring to?
No, in the third argument, you seem to in your third argument, you seem to both argue that it's fundamental error, that the trial court fundamentally erred, and that trial counsel was ineffective. Which argument are you making?
I'm making the argument. Excuse me, I'm sorry. I'm making the argument that the trial counsel was ineffective. The JOA was the one time that he did indicate that he was present at the trial court and was going to raise an issue. That's the only way that he actually preserved anything as far as the issue that I'm raising on the ineffective assistance. That's why I weave that into the argument. But ultimately, it was his lack of doing anything with the jury instructions to force the state to prove each element beyond a reasonable doubt in this case.
All right, if you want to, you're into your rebuttal time. Do you want to save the rest of your time?
I'll save the rest of my time.
May it please the court? May it please the court? Thank you. My name is Kaylee Tapman on behalf of the state of Florida. None of the arguments that appellant has raised in the issue 3 were preserved below. It seems that the main contention on appeal is that the state failed to ask one question, and that question is whether the 3,4-methylene dioxy-alpha ethylamino valeriphenone was a 2-amino, 1-phenol, 1-propanone structure. Had this argument been raised below, the state would have been able to reopen its case, which would not have prejudiced the defendant because it's only about what kind of controlled substance versus whether it is a controlled substance. And we wouldn't be here because the question would have been answered. I disagree with appellant's argument that trial counsel didn't consider this argument. He filed numerous motions pre-trial to obtain an expert to test the substance. And ultimately decided at the beginning of trial not to call that expert. He said it was a strategy call, and appellant agreed with that decision. And I think that shows that there was no factual basis to dispute that this was a controlled substance under the appropriate Florida statute. I don't think you can show an effectiveness on the face of the record because it was a strategy call, and the defense counsel explained that it was the beginning of trial. When considering an insufficiency of the evidence argument, it can only be fundamental error if there's no evidence that any crime occurred. And here the FDLE analyst testified that the substance was a controlled substance, and so clearly there was a crime that occurred. And as to the jury instruction, even if the court was supposed to instruct the jury to find this substance as a controlled substance, which is not part of the standard jury instructions, failing to instruct on an undisputed element is not fundamental error. And in here, I think it's clear that all parties agreed that 3,4-methylene dioxy was a controlled substance, and therefore the jury was properly instructed. Are there any questions?
Yes, counsel. It seems to me that the appellant's first argument might be the most interesting one. Would you like to address that?
Sure. we would submit that the appellant did open the door to his own impeachment by eliciting self-serving hearsay on the cross-examination of the officer. This was a strategy to which—
Who brought it out first, counsel?
defense counsel is the first one to bring it out on the cross-examination of Officer Williams. He asked the officer whether the defendant made a statement that the substance was Epsom salt. That officer did not know whether that statement was not made to that officer. However, it created an implied assumption that the defendant did make such a statement. And then after the recorded interview was played, he then re-emphasized that statement to the second officer, Detective Olson, therefore placing his credibility at issue because he was eliciting his own self-serving exculpatory hearsay. But more further, any armlet.
Where was it implicit, counsel, again?
And during the first officer, Officer Williams, when he asked specifically those statements that the defendant said would have included him saying that the substance was Epsom salt, right? Creating an implied assumption that it was. But more importantly, any error was absolutely harmless because the appellant chose to testify at trial. So this evidence of his prior convictions was going to be admitted regardless. And defense counsel even admitted that when the trial court made its ruling that the state could present those prior convictions, defense counsel immediately said, that's all right, it's a moot point anyway, because my client is going to testify. And then he did choose to testify. And the appellant got a limiting instruction that the jury could only consider those prior convictions for purposes of determining his credibility, which is not something he would have received contemporaneously if the information had only come out when he testified. And so it is absolutely 100% harmless. If there are no further questions, rely on the remaining arguments made in the brief and ask that you affirm. Thank you.
Thank you. We got just about 3.5 minutes left.
Thank you, Your Honor. I want to respond to the state on the first issue of the brief, which was regarding the opening the door situation. As far as whether or not the door was open, the defense, based on my understanding of the law in Knockney State, did not open the door in this case. His first question to Officer Williams was very clearly not eliciting self-serving hearsay, because in order for that to have happened, it would have had to have been asked to someone who had knowledge. Officer Williams did not have knowledge. The next officer that did have knowledge.
Right, but he made the defense counsel made known to the jury at that point that your client had made statements that he thought it was Epsom salt. Williams was just very straightforward and said he didn't say that specifically to me. And at that point, the trial judge warned the defense counsel and warned the defendant. He said, okay, we're not there yet, but if you guys ask this of somebody who does know, you're opening the door. And everybody on the defense side said, we understand. And so when the next detective came up and was asked about it, it shouldn't have come to anybody's surprise that it was permitted, especially when defense counsel said he agreed with the underlying law. How is that error?
Well, my understanding of the record is that after the initial conversation with Officer Williams, the next person, the state was the next person to bring, or the next party to bring up the self-serving hearsay allegedly. And whether or not it's actually self-serving hearsay, I believe is in question because the state is the one who brought it up. The state asked the question first. They admitted the audio recording where Mr. Wilson made the statement. And so ultimately the state had the opportunity to use it for whatever purpose, that statement did for them. If they're arguing, the idea of self-serving hearsay is it's not supposed to be helping the state. So that's why they have the opportunity.
Under the evidence code, it's not hearsay if it's a statement of a party opponent and a statement of a party. And that's what this is. So it's not hearsay. It doesn't become hearsay until defense counsel asks about it. It's, that's classic evidence.
Correct. And ultimately the state admitted the statement and then direct examined the witness about the statement. And all the defense counsel did was cross-examine in response. And the state was having the benefit of using that to open the door to the convictions. Mr. Wilson did end up testifying. He did end up agreeing on the record that he was okay with that. I don't believe that this court should put a lot of weight into Mr. Wilson's agreeing to that. It's very similar to if you're on a surgeon table and a doctor says at the last minute, right before he's about to put you under, that we need to adjust the strategy in order for this procedure to go well. You're going to do whatever he says because you don't have the innate ability to understand all of the decision making. And this happened. They talked about it for about, I believe, 15 minutes tops on the record, and that was a decision that Mr. Wilson made in the heat of the moment with his trial attorney. And the
That
trial
discussion
attorney,
sounds like something good for a 3850 maybe, but not for on the face of the record. I mean, he said it, he was warned, everybody knew what was going on, and everybody agreed with the law at the time. I don't see how that's error for appeal. And
Yes,
you're out
Your
of
Honor.
time. So thank you very much. We'll be in recess until 10 o'clock.
thank you, Your Honor.
Thank you.